Namaste, this is Advocate Surya Kundeti and this is my class on Civil Procedure Code 1908. As said in my earlier classes, doing these classes for charity purposes. All my classes are dedicated to a charitable organization. The name of the charitable trust is ABC Trust. So I'm of the opinion that you will definitely like my classes, and as an token of gratitude, you can make a small donation of ₹59 towards the charitable trust to the UPI number. The UPI number is 9949398998. At the end of this class, there will be a display of the QR code for you to enable the transaction using the QR code through the EPI. And please don't forget subscribe to my channel so that your subscriptions are going to be an encouragement for doing more classes and for the benefit of the society as well. Today we have a very interesting topic. The topic is appearance and non-appearance of parties in legal proceedings. The legal framework governing court proceedings is fundamentally built on the principle that no party should be disadvantaged by decisions made in their absence. This ensures fairness and due process for all involved. What are the general principles involved in this one? Courts operate on the core belief that all parties to the lawsuit should have a fair opportunity to present their case. This is achieved through establishment rules regarding their attendance in court. Appearance of parties, mandatory presence. As per Rule 1 and Rule 12, both the plaintiff, the party initiating the suit, and the defendant, the party against whom the suit is filed, are generally required to attend court either in person or through their legal representative, who could be an advocate or a pleader or an attorney, on the date specified in the summons. Consequences of a non-appearance. If a party ordered to appear in person fails to do so without sufficient cause, if it's the plaintiff, the court may dismiss the suit. If it is a defendant, the court may proceed ex parte without the defendant's presence. Scenario of non-appearance. Neither party appears. Rule 3. What does this mean? If neither the plaintiff nor the defendant is present when the case is called for hearing, the court has authority to dismiss the suit. Only plaintiff appears. Rule 6 and 10. When the plaintiff is present but the defendant is not, the plaintiff must demonstrate that the summons were properly served on the defendant. If successful, the court may proceed ex parte against the defendant and potentially issue a decree in the plaintiff's favor. Only defendant appears. Rule 7 and 11. If the defendant appears but the plaintiff does not, and the defendant does not admit the plaintiff's claim either wholly or partially, the court is mandated to dismiss the suit. Summons not served. Rules 2 and 5. The cornerstone of procedural law is that party must receive proper notice of legal proceedings initiated against them to have a fair chance to present their case. If a summons is not duly served, the proceedings may be impacted. What is ex parte decree? Meaning, an ex parte decree is a judgment passed by the court when the plaintiff is present but the defendant is absent despite having been properly served with a summons. Such a decree is not inherently void or invalid. Instead, it is voidable, meaning it remains legally valid and enforceable unless and until it is successfully challenged and set aside on legitimate grounds. It holds the same legal force as a decree passed with both parties present. So, remedies against an ex parte decree. The defendant against whom an ex parte decree has been passed has several concurrent remedies available to challenge it. Application to set aside. Order 9, Rule 13. The defendant can apply to same court that issued the decree to have it set aside. This is common and direct method to challenge the decree. Appeal Section 96 subsection 2 or section 115 for revision. An ex parte decree falls under the definition of a decree as per section 2 subsection 2 of the Code of Civil Procedure 1908. Therefore, an aggrieved party can file an appeal under section 96 subsection 2. If an appeal is not in permission, a revision application can be filed under section 115 if the order setting aside an ex parte decree qualifies as a case decided. Application for review. Order 47, Rule 1. If the conditions stipulated in Order 47, Rule 1 are met, example, discovery of a new and important matter or evidence, a mistake or error apparent on the face of the record, or any other sufficient reason, the aggrieved party can apply for review of the decree. Separate suit on grounds of fraud. While a general suit to set aside an ex parte decree is not maintainable, an exception exists. If the ex parte decree was obtained by the plaintiff through fraud, the defendant can initiate a separate lawsuit to challenge it. It's a fundamental legal principle that fraud violates even the most solemn transactions. In such cases, the burden of proof lies with the party alleging fraud. The first hearing in civil suits, what does it mean? The first hearing of a lawsuit is a pivotal stage in the judicial process occurring after the initial exchange of pleadings. While the term is not explicitly defined in the procedural code, it signifies the point at which the court delves into the parties' arguments to understand the core contentions or intentions of the dispute. This stage typically involves the framing of issues, which are the specific points of disagreement between the parties and the court needs to resolve. Object of the first hearing. Order 10, Rule 1 mandates that at the first hearing, the court must ascertain from each party or their legal representative which allegations of fact made in the plain or written statement are admitted or denied. This helps in narrowing down the disputed areas and focusing the trial on contested facts. Alternate dispute resolutions, which is short form of ADR. The Code of Civil Procedure, through Order 10, Rule 1A, 1B and 1C, inserted by the 1976 amendment, emphasizes exploring alternate dispute resolutions ADR mechanisms. At the first hearing, the court may refer the parties to conciliation, mediation or a lok adalat to attempt an out-of-court settlement. If a settlement is not reached, the case is then referred back to the court for further proceedings. Framing of issues and what does framing of issues mean actually? An issue represents a point of contention, an important subject of debate, disagreement or discussion in a legal dispute. In essence, issues are the specific questions of fact or law that the court must answer to decide the case. So, framing of issues falls under Order 14, Rule 1. Issues emerging from a material proposition of fact or law is affirmed by one party and denied by other. Material propositions are those statements of law or fact that a plaintiff must assert to establish their rights to sue or that a defendant must assert to build their defense. Object of framing issues. The primary goal of framing issues is to precisely identify the actual controversies and rival contentions between the parties. This clarifies what needs to be proven or disproven during the trial. So, kinds of issues which falls under Rules 1 to 2. Rule 1, Sub-Rule 4 categorizes issues into two parts. What are they? Issues of fact. These involve disputes over what actually happened. Issues of law. These involve disputes over the correct legal interpretation or application. Preliminary issues. Certain issues, particularly those related to jurisdiction of the court or a legal bar to the suit, may be designated as preliminary issues. Prior to the 1976 amendment, Rule 2 of Order 14 required courts to decide issues of law as preliminary matters. However, the amendment Rule 2 now grants the court discretion to try such issues as preliminary. This allows for early resolution of fundamental questions that could potentially dispose of the entire suit, saving time and resources. Importance of issues. Issues are often considered the backbone of a lawsuit. Their proper framing is crucial for the trial's direction and the eventual decision. Importantly, it is the framed issues rather than merely the pleadings that guide the parties on what evidence to present during the trial. What is a court's power and duty towards these issues? The primary responsibility for framing correct and comprehensive issues rests with the court. The presiding judge must diligently analyze the case and its facts as well. While the courts bears the sole obligation, legal representatives for both parties are expected to assist the court in this crucial task. The quality of issuing framing often depends significantly on the judicial officer's analytical and drafting skills. That is the reason as to why it was discussed in our earlier classes that advocates are the persons permitted by the Constitution of India and empowered them to have tripartite duties. they are responsible for the society, they are responsible for the judge, and they are responsible for the client as well. So it is the advocate's duty to protect both these important estates: constitution, judge, society, and the client as well. Matters from which issues are framed. Rule 3. Issues are typically framed based on allegations made under oath by the parties or their representatives, or statements made by their pleaders or advocates. Allegations contained in the pleadings, plaint and written statement, or in answers to interrogatories. Interrogatories means questions. Documents produced by the parties. Amendment of issues. While it's the court's duty to frame appropriate issues, failure to do so is not necessarily fatal to the suit. Issues can be amended at any stage of the trial to ensure all relevant points of dispute are covered. We have omissions to frame issues. What are they? Even if the court omits to frame the specific issues, it's considered an irregularity that may or may not be material. If such an omission significantly impacts the fair disposal of the suit on its merits, the case might be remanded to the trial court for a fresh trial after proper issues are framed. Disposal of suit. Order 15. The Code of Civil Procedure provides for various scenarios where a suit can be disposed of without a full-fledged trial, often at an early stage, particularly if certain conditions are met. What could be those conditions? No dispute on law or fact. The parties are not at odds on any question of law or fact. The court may proceed to judgment. Admission by defendant. If there are multiple defendants and one or more admit the plaintiff's claim, the court may pronounce judgment against the admitted defendants. Failure to produce evidence. Summons for final disposal. If the summons were issued for the final disposal of the suit and either party fails to produce their evidence without sufficient cause, the court may proceed to dispose of the suit. Admissions by party or pleader. If a party or their pleader makes admissions of facts that are sufficient to resolve the case, the court may dispose of the suit based on these admissions. No further argument or evidence required. When? After issues have been framed, if the court is satisfied that no further argument or evidence is necessary to decide the case, it may proceed to judgment. So these are all the many important aspects related to our suits. And we have some more things: discovery, inspection, and production of documents in civil suits. This discovery and inspection and production of documents in civil suits are vital for the judge or the judiciary to finalize the judgments. In civil litigation, after the initial exchange of the plaintiff's plaint and the defendant's written statement, parties often find that their opponent's case is not fully disclosed in the pleadings. To ensure a fair trial and prevent surprises, the Code of Civil Procedure 1908 provides mechanisms for parties to obtain relevant information and documents from their adversaries. It's crucial to note, however, that these provisions are not intended to allow a party to discover the opponent's evidence prematurely, which could lead to its destruction and defeat the ends of justice. The Code of Civil Procedure addresses this through 4 key areas. What is the first one? Discovery and inspection, Order 11. Admissions, according to Order 12. Producing, production, impounding, and return of documents, Order 13. So, affidavits, Order 19. So, these are the 4 points or the 4 ways of producing the evidences. So, discovery and inspection, according to Order 11. What is this discovery and what does it mean? Discovery refers to the presence of compelling the opposing party to reveal facts or documents that are in their possession or power and are relevant to the issues in the suit. It's a compulsory disclosure designed to clarify the case. Nature and scope. Once issues are settled, a party may seek information from their adversary regarding facts or documents relevant to the case. When factual information is sought, it's done through a series of questions called interrogatories. Interrogatories means a series of questions. The court reviews these proposed questions and, if deemed appropriate, compels the other party to answer them under oath before the trial. This is known as discovery of facts. Object. Section 30 Code of Civil Procedure empowers courts to order discovery. Modern procedural courts increasingly emphasize full disclosure to ascertain the truth. Unfortunately, this crucial provision is often underutilized by the judges. Interrogatories. Rule 1 to Rule 11. What exactly is the meaning of these interrogatories? Interrogatories are written questions posed by one party to the other, requiring thorough and sworn answers regarding facts relevant to the suit. What is the objective of this interrogatories? The purpose of interrogatories is twofold. The first one is to understand the opponent's case. This helps a party to grasp the arguments and factual assertions being made against them. Second one is to support one's own case. This can be achieved either directly or obtaining admissions from opponent, or indirectly by undermining or refuting the opponent's case. Who may administer and against whom allowed? Generally, any party to a suit can administer interrogatories to any other party, plaintiff to defendant, and vice versa. And form of interrogatories. Interrogatories should adhere to the forms prescribed in form numbers 1 and 2 of Appendix C of the Civil Procedure Code with necessary adoptions. This is very important when framing the interrogatories. If the interrogatories framed are not as per the said rules, then there will be chances for objections from the judge. Objections to interrogations. A party can object to answering an interrogatory if it is deemed scandalous, irrelevant, malafide also, in bad faith, immaterial, or underprivileged. Rules as to interrogatories. In this context, there are certain rules that are framed. So what are those rules? Interrogatories must be administered in writing and only with the leave of the court, subject to any conditions or limitations the court may impose. The proposed interrogatories must be submitted to the court, which should decide on their admissibility within 7 days of application. They can be administered either the plaintiff to the defendant or the defendant to the plaintiff. Interrogatories that can be allowed. As a general rule, interrogatories are permissible when their answers would either prove the case of the party asking the questions or demolish the case of the adversary. This right is considered valuable and should not be lightly denied. Interrogatories which may not be allowed. Questions seeking to discover facts that constitute exclusively the evidence of the adversary case. The purpose of interrogatories is not to reveal how the opponent intends to prove their case. Questions concerning confidentiality and privileged communications between a party and their legal advisors. Non-compliances. Effect. If a party fails to answer interrogatories, the party who administered them can obtain a court order compelling an answer either by affidavit or oral examination. Appeal and revision. An order granting or rejecting a prayer for interrogatories is neither a decree nor an appealable order. Therefore, an appeal lies against such an order, which, while such an order might be considered case decided, under Section 115 for revision, High Courts typically do not interfere with the court's discretion unless the order is clearly erroneous or illegal. So, discovery of documents. This is one more important point under which falls under Rules 12 and 14. Nature and scope. What does it mean? Discovery is broadly categorized into two types: discovery by interrogatories of facts and discovery of documents. Generally, a party has the right to inspect all documents and that are relevant to the case and do not constitute exclusively the other party's evidence of their own case or title. Object. The objectives of document discovery are to secure, as far as possible, the disclosure under oath of all material documents in possession or power of the opposing party with penalties or false oaths. To avoid a protracted inquiry into which material documents are actually in the opponent's possession. Who may seek discovery? Any party to a suit may apply to the court for a discovery order either by filing an affidavit or through other means. If the court orders discovery, the opposing party must provide an affidavit listing all relevant documents currently or previously in their possession, custody, or power. Against whom discovery may be ordered. Discovery orders are typically made against a person who is a party to the suit, including, for example, binamidar or a custodian as well. Conditions. Discovery of documents may be ordered if it is deemed necessary for the fair disposal of the suit and for saving costs as well. So what is the object against discovery? Discovery can be objected to on the grounds that it is unnecessary or premature at the stage of the suit. Any objection must be clearly and expressly stated in an affidavit, not merely by claiming privilege. For example, if somebody is having or holding the title deeds of a property which is owned by some B, then if A refuses to hand over the title deed documents that belongs to the ownership of B, then B can approach the court and ask for the discovery of the documents, and the documents can be ordered by the court to be submitted to the court. In such case, the title deeds will be discovered and they will be handed over to the rightful title owner. This avoids further litigation and it saves costs as well. So, in such cases, discovery of documents can be ordered. Admissibility of documents. Discovery may be ordered for any document that is relevant and has a bearing on the matter in issue. For example, if A is a title owner of the land and he wants to sell off the property, but the property documents are with B. Now, B doesn't want A to sell the land because B has intentions to get the property of A at a lesser price. Now, understanding this, A can go to the court and file a discovery of the documents case against B, and the court will definitely order for discovery of the documents, and then B has to prove to the court that he's not the custodian of the documents. But if he is the custodian of the documents, he had to submit those documents to the court. So, documents disclosing evidence. Documents that constitute the exclusive evidence of a party's own case cannot be ordered for protection. The discovery provisions are not meant to allow a party to know how their opponent intends to prove their case. Privileged documents. English law recognizes crown privilege based on the principle that public welfare is paramount. Public interest may necessitate withholding documents in certain circumstances. However, if a claim of privilege is made, the court generally has the power to inspect the document to determine the validity of the claim. So, the mere assertion of privilege by the opposition party is not conclusive. And oppressive discovery. Discovery may also be resisted if it is unduly oppressive to the party providing the discovery. The court balances the importance of the discovery to the requesting party against the burden placed on the party providing it. And non-compliances to the discovery. Effective. If a party fails to comply with an order to produce documents, the court may draw an adverse interference, assuming that the documents have been produced, they would have been unfavorable to that party. Rules as to discovery. Any party can apply to the court for an order directing the other party to disclose under oath all documents that are or were in their possession or power relating to any matter in question in the suit. After the discovery, we have one more interesting point called as the inspection of the documents under rules 15 and 19. What are these rules 15 and 19? Specifically deal with the inspection of documents. For inspection purposes, documents specifically referred to in the pleadings or affidavits of the parties and other documents mentioned in their pleadings. So, privileged documents. Certain categories of documents are considered privileged and are generally exempt from inspection. So, documents that exclusively evidence a party's own case or title, and confidential communications between the client and their legal advisor. All these points are confidential documents which cannot be asked under the discovery. And public official records relating to the state affairs and confidential official communications, if their production would be detrimental to public interest. See, for example, we have almost all the national interest, national safety and state safety under the confidentiality folders. So, these cannot be discovered under any court orders because they are going to be they may harm the public interest or detrimental to the public interest as well. So, next point is a premature discovery of Rule 20. The court has the authority to postpone discovery or inspection if it is considered premature. This occurs when the right to discover depends on the determination of another issue or question in dispute, or when it is otherwise desirable to resolve a preliminary issue before ordinary discovery. So, non-compliance with the order of discovery or inspection, Rule 21. So, what happens? Failure to comply with an order for interrogatories, discovery or production of documents can have severe consequences. What are the consequences? If the non-complying party is a plaintiff, their suit may be dismissed for want of prosecution. If the non-complying party is a defendant, their defense may be struck off placing them in a position as if they had not defended the suit. And admissions or order 12. Nature and scope. So according to section 58 of the Evidence Act 1872 states a fundamental principle: facts admitted need not be proved. Admissions can occur before or after the suit is filed. The primary goal of obtaining admissions is to eliminate the need to prove facts that are already conceded, thereby allowing judgment and decree to be passed more swiftly on such admitted facts. As it's often said, what a party admits to be true can reasonably be presumed to be true as well. So, what is the object behind this? The core objective of admissions is to dispense with proof, saving valuable court time and further resources as well. So, what is the importance of these admissions? Admissions are an extremely powerful form of evidence because admitted facts do not require further proof. This saves time, reduces expenses, and expedites the trial process. The principle that what a party admits to be true should be presumed to be true is a cornerstone of Civil Procedure Code 1908. How it can be admitted, or what are the kinds of admissions? Admission can take various forms, including those made formally in pleadings, responses to notices, or during examination. Conclusiveness of admission. An admission is not conclusive as to absolute truth of the matter stated. It serves as a piece of evidence and its weight depends on the circumstances under which it was made. An admission can be shown to be erroneous or untrue. For example, custodial confessions are not admissions. Admission should be taken as a whole. Parted admissions cannot be taken. Court cannot accept only a part of an admission while rejecting the rest as well. Notice to admit case or rule 1. Any party can serve a written notice on the other side stating that they admit the whole or any part of the opponent's case. Judgment on admissions, which is Rule 6. Rule 6 empowers the court to pronounce a judgment based on admissions made by the parties without waiting for the determination of other disputed questions. The purpose of this rule is to allow a party to obtain a speedy judgment, at least for the relief to which they are clearly entitled based on the opponent's admissions, thereby expediting the resolution of undisputed parts of the action. Production, impounding and return of documents, Order 13. Nature and scope. The plaintiff is required to produce with their plaint the documents they are suing upon along with a list of supporting documents. Similarly, summons to a defendant should direct them to produce all documents in their possession or power that they intend to rely on for their defense. Order 13 comprehensively governs the production, admission, impounding, rejection and return of documents. Production of documents, what is Rule 1 states? Rule 1 of Order 13 mandates that parties or their pleaders must produce documentary evidence on or before the settlement of the issues. This provision aims to ensure a fair trial, prevent the introduction of forged or manufactured evidence, and encourage the earliest possible disclosure of documents to the court. It also seeks to prevent the belated production of documents which could prejudice the other side. Admission of documents, Rules 4 to 7. Rule 4 stipulates that every document admitted into evidence is a suit must bear specific endorsement. The suit number and title, the name of the person producing the document, the date of production, the statement confirming its admission into evidence. The judge must sign this endorsement and these rules must be strictly adhered to. Return of documents. After examination, the documents can be returned. What are these? Rules 7 and 9. Documents not admitted into evidence must be returned to the person who produced them. Rule 9 allows for the return of an admitted document to the producing party after the suit or appeal is disposed of, or even during the pendency of the suit, provided an undertaking is filed to produce the original if required. Generally, this is not permitted without a notice to the other side and without producing a copy of the document as well. Rejection of documents, what does it mean? Rules 3 and 6. The court has power to reject any document if it deems irrelevant or inadmissible at any stage of the suit, provided reasons are recorded. The rejected document should be endorsed with the particulars mentioned in accordingly in rules 4 subsection A subclause A to C, and a statement indicating its rejection as well. Impounding of documents, rule 8. Rule 8 empowers the court to impound a document for sufficient cause. This means the court can direct any document, book or exhibit produced before it to be seized and kept in their custody of a court officer for a specified period and under certain conditions. While Rule 7 deals with return of unadmitted documents, Rule 8 pertains to documents that have been admitted into evidence. Affidavits. Affidavits means though not formally defined in the Code of Civil Procedure, an affidavit is commonly understood as a sworn statement in writing made specifically under oath or affirmation before an authorized officer or magistrate. Simply put, it's a written declaration of facts sworn before a person authorized to administer oaths. Every affidavit should be drafted in the first person and should contain only factual statements, not inferences or arguments. Essentials. What are the essentials? The key attributes of an affidavit are: it must be a declaration made by a person, it must relate to facts, and it must be in writing, now and under typing. It must be written in the first person, and it must be sworn or affirmed before a magistrate or other authorized officer. What could be the contents of the affidavit? An affidavit should generally be limited to facts that the deponent, the person making the affidavit, can prove from their personal knowledge. However, Rule 3 Subrule 1 of Order 19 allows for statements based on belief, interlocutory applications made during the pendency of the suit. Interlocutory applications means applications made during the pendency of the suit. Evidence on affidavit, rules 1 to 3. A court may order that any fact be proved by affidavit. Ordinarily, facts must be proven through oral evidence. Since affidavits are not included in the definition of evidence under Section 3 of the Evidence Act, they can only be used as evidence if the court, for sufficient reason, invokes the provisions of Order 19 of the Code of Civil Procedure 1908. Affidavits must be properly verified and conform to the rules, or they will be rejected by the court. False affidavit. This is very, very dangerous. Swearing a false affidavit is a serious offence alike to perjury and is punishable under the Indian Penal Code. It's a grave matter and a lenient view is generally not warranted. When a false affidavit is filed by a government official, particularly strict action should be taken. As I have said in my earlier classes, I am dedicating all my online classes to a charitable organization by name ABC Trust, and if you are very much if you're fond of my classes as well, I may plead you through this video, please donate 59 rupees to the ABC Trust, and your donations are going to be utilized for improving the child nutrition, going to school, and also for their educational needs as well. The UPI number is 9949398998. In addition to it, at the end of this video class, we are going to show you an QR code as well, which will be easy for you to enable you to scan the QR code using your UPI app and make the donation of 59 rupees. I hope you do like my classes very much, and thank you very much. I'll see you in the next class. Namaste.